No, we're not. Good evening. This is July the 24th, 2025, meeting of the St. Mary's County Board of Appeals, located in the Commissioners of St. Mary's County Meeting Room of the Chesapeake Building, 41770 Bulger Street, Londontown, Maryland. I am Chairman George Allen Hayden Sr., here with 4 other board members. We have met our minimum requirements for a quorum and will now proceed with our meeting. And we'll start to my left with the introductions.
Donald LaRocco,
Good evening, I'm Rita Weaver.
John Brown,
Ronald Payne.
And Steve Scott, our board attorney, is with us this evening. And John Sterling Hauser, deputy county attorney. Stacy Clements, planner 4, land use growth management. Amy Carter, video media producer. We have 2 public hearings on our agenda for this evening, and our first case this evening is a variance request, ZAAP 24-0997/J, J. Whitson Rogers appeal, and it's withdrawn by the applicant on 7/23 of 2025. Mr. Hauser, do you want to update the board of where we are with that, please?
As the chairman indicates, the applicant has withdrawn the pending appeal on the permit. That was because, you might remember, this was originally set back in June, and staff asked at that time a continuance to give staff the time to re-review how they had initially processed that permit. That review did result in staff determining that an exemption for formal stormwater management review that had been granted in error. So staff revoked the permit pending formal stormwater management review, and the permit will be subjected to that. And while that plays out, the revocation of the permit means there is no final decision to take an appeal from. So for the moment, that appeal is moot.
Okay. So, thank you, sir. Our second case this evening is a continuance of the June 26, 2025 hearing for a variance application CUAP 25-0035, Drift In Communications Tower. Ms. Clements, there was,
We gave a staff presentation and the applicant was
right,
responding.
we're right there with his, probably halfway through his presentation, but we had some more communications.
Yes, yes. I know in regards to, I'm sorry, with regards to the co-location for the county, having first.
Right of refusal?
Yes, yes,
Okay.
right of refusal. Perfect, thank you. We reached out to emergency services, and they've directed us to the right people to talk to. So we are currently waiting for their response.
Okay.
As to whether they require co-location or the right of refusal, as you
Okay.
stated.
And have we had any more written public comment
No,
since our
sir.
last hearing?
No, sir.
We have not. Okay. Thank you.
You're welcome.
Mr. Fisher? We'll get you sworn in again this evening, sir, please. Do you declare and affirm under the penalty of perjury that the testimony, responses, and the statements you may give will be the whole truth and nothing but the truth?
Yes, I do.
Thank you. So it's the ball's in your court, so.
So counsel is here, should be here shortly, just so you know. He's coming from Easton on another matter. So he'll be here shortly. In the meantime, I think the last question that we had concerned the distances. And this probably is counsel here. Indeed it is.
Okay.
And I'm going to turn it over to him.
Okay.
No worries, perfect. We just started.
Hi.
I
If
didn't even
you
fill 'em.
would, for the record, I need you to speak into the microphone when you make comments. If you would, for the record, if you give us your name and address and affiliation with this project, please.
Happy to do so. Ryan Showalter, 100 Northwest Street, Easton, Maryland, and I'm appearing tonight as counsel for Telecom Capital Group, the applicant.
Okay? And for the record too, Mr. Fisher, if you would, please, just your name and address again, please.
Sure,
Just so
Mark
we have
N.
it on, just so
Fisher.
we have it on record. So,
Managing Member, Telecom Capital Group, 6150 Sheridan Point Road, Prince Frederick, Maryland, 20678.
all right, great, thank you. So who would like to start?
Well,
So, Mr. Fisher, before we ask Mr. Showalter to jump in here, why don't you just give us an update of where we are with your project right now, okay? What we've been through, just a high level, so we can remind everybody of what we've talked about. If you
Sure.
would be-
So Telecom Capital Group, the last time that we were here, provided the PowerPoint presentation, which showed you the need, defined the need. The need was further defined and is further defined in the RF report that you have. There's also an alternatives analysis in the RF report, which staff asked for. It's very thorough and exhaustive of what else could we use. That's what I mean by alternatives analysis, other than the site at hand. The RF engineer provided that information, and we went through that information as well. We do have the RF engineer here, of course, on Zoom, as well as the civil engineer, in case if there are any additional questions. And then we quickly progressed to a question from Mr. Payne about the distances of the pole to the closest structure. And since that time, I think we've had some clarifications from the county attorney's office, and perhaps I think they might better speak to that better.
Okay. Mr. Hauser, would you like to address that, please?
Yes, I think what Mr. Fisher is referring to there, board members might remember one of the questions asked was the setbacks that apply in this case and what structures do they apply to, and specifically what we're looking for is in the code. It's 51.3.91.b. Give me one moment. 10.
10.
Which
Right.
reads out that in addition to any setbacks otherwise required by the zoning ordinance, tower shall require a setback distance of 100% of the height of tower from any residence, historic site, building, or other structure not associated with the tower site. And I think what we got was the confusion of what does it mean to be associated with the tower site. Because when you look at the site plan on this project, you'll see that there are some structures proposed to be remaining on Mr. Adams's property that would be within that thing. Mr. Adams, the property owner of the parcel that the cell tower is going on to, who's leasing the spot to Mr. Fisher. And I think when I read that, initial impression is what does it mean to be associated with the site? I think the way that site development envelope are defined in the CZO, the best way to look at that is a site that's under common ownership, or property that's under common ownership as the property that's going on the cell tower. So in other words, I think that if Mr. Adams, he owns the property, if he wants to keep his structures within that setback, it's fine. I don't think that triggers the need for the setback or need for a variance. Because again, that would be structures on the site that's associated with the cell tower, is how I would look at that and read it.
So his house, if his house is within the 200 feet, it doesn't
It's not.
matter.
So it's not in this case, and I think the theory on there of how I get there is that if the property owner has an issue with that, or doesn't want their house to be that, or any structure of theirs to be located that close to the cell tower, they always have the option not to enter into a lease
Okay.
and not allow it in there. So I think that if the property owner is consenting to it going forward and, allowing the cell tower to go up there, you read that. And I think really what you're looking at there is to protect the neighbors who may or may not have a direct say in whether the cell tower goes up or not. It's just, I think, a little nonsensical that owner who could have stopped it from the beginning, who could have not put the cell tower up there at all, now has to go and sign a piece of paper saying he consents to the cell tower going up there and him keeping structures within the setback. The alternative, I think, is we conclude that's not, you just grant a variance instead. That's your other way around it. But I just don't think my read of the law and what associated with the site means the setback requirement should be triggered at all.
Okay.
Again, if the property's under common ownership there. Because obviously if we had a structure within that fallback, it's on the neighboring property, totally different situation, but that's not what we've got in the case at hand tonight.
Thank you. Mr.
Yeah,
Scott?
Mr. Chair, I think that makes perfect sense when we look at these ordinances. Obviously, we spend a lot of time trying to interpret exactly what they mean, and I think certainly we hope that logic rules the day, and I think that's a logical interpretation of the ordinance.
No. And I'll just say, too, one of the more dispositive things is that when you go back in the definition of site and development envelope for the purpose of this, you are specifically instructed to consider any required setback areas as part of the quote-unquote site. And I think that is not, I don't know how I can read the words associated with the site to mean anything other than at least the parcel under common ownership with the cell tower project itself. I'm just not sure how I can get there.
Okay, and I think I'm okay with that.
Yeah.
As long as we don't go outside that property line.
Yeah.
Correct? Is the way I understand that?
Is when we say that, we're asking, would we apply it to structures that are beyond the property line, right? Yeah, no, total agreement there. And there aren't any structures within the fall setback or the 100% height on this one, right? Outside the,
But,
yeah.
but even if you go beyond the property line, it still requires notarized response
Yeah, and I get
by those property owners.
And I get that one in there at that sentence too, requiring a notarized statement of agreement or an easement must be obtained from the adjoining property owner. And that's another one I struggle with because the word easement jumps out to me on that one, and I'm not sure the propriety or the constitutionality of requiring a quote-unquote easement on another person's property. A notarized statement's another thing. I think the way about that one, even if we were to assume it applied here, just grant a variance as part of a condition, because that's how you get around it. That makes sense.
If this was not even here, I mean, think about why was it even written, Counselor? Because if it wasn't written, we would be going along with what you say right now.
Yeah.
So in my mind, because it is in writing, it's implying what's been going on for the last, 9.5 years that I've served on this board, which said basically within the property as well as going across the property lines. And actions have been taken along those lines. We're suddenly reversing course here. I just want everybody to be aware of that.
I get it. And
I think even so, we had this similar situation on our last request for that in its same tower in a different location. And it come up, and if I'm not mistaken, we'd have to go back and take a look, but I think the property line with the different property owners played a lot in that decision on that one.
yeah,
So
I get to.
I think the property line could be an issue.
Correct. And they have
I mean,
see
I see it as that as well.
Okay. I think maybe the safest thing to do is I think not as a condition, we would just also grant, if the board would see proper to approve the project, you just grant a variance from the
to pass.
setback requirements with respect to the other property then. I think that's a way to get through it procedurally tonight, if we wanted to assume it applied.
So the request would have to be not only condition, but variance also.
So we'd get, yeah, because the issues
Variance
arisen
from
here in the moment.
From the condition.
Right, and that as part of the approval, we'd just grant a variance from that setback
Do
if
we-
we wanted
we have
to apply.
If we're changing from a conditional use to a variance, do we have to re-advertise this thing?
I'll
If we
defer.
go into a variance to stop this property line issue, then someone on that other property has to be physically notified.
So, I'll defer to Mr. Scott on this one, but I think the way I can get on that one is our requirements when we provide notice of a hearing, you don't have to allege with absolute precision what is going to happen in that hearing or what's going to be discussed. You have to give them enough of an idea where a person of general reason and understanding can know what the issue is. Here, the affected property owners would have gotten notice, they would have gotten mails for the conditional use approval. That would have shown cell towers being put up and seen the site plan.
For the conditional use, but in order to grant a variance to allow that to go, even if it's in the full distance of that line, according to our CZOs,
So,
someone from that property has got to give us some sort of a testimony, I would think.
Well, that's why I wanted to know, because there were two people that wrote that were in opposed and two people that were for it, and I wanted to know where each person was located. Because the one, it was, I think, it's like 57 feet to the property line, 57.7. And like, I wanted to know who lived there on the other side. Like where each person is located.
Yeah, I am, so I'm looking up trying to see where they get it from. I'm also confirming, we do have Stacy in the record, just make sure that, we do have the certified mailings that the adjacent property
There.
owners all got.
Yes,
Okay,
the
we
green.
do have that.
I want to make sure I understand, John, what you're saying. So you're saying a conditional use that may require a variance as well.
I think if you want to, right, if we want to take that sentence where, again, it reads out, if the setback is to be on an adjoining property, a notarized statement of agreement or an easement must be obtained from the adjoining property owner. I think the absence, if we want to assume that applies here, the way to
So-
get around that would be a variance. That
Yeah.
would just be a standard setback variance.
The
And
int-
then I think the question is.
The interpretation that you mentioned when you sat down, that of course was vetted with the zoning officer. The zoning officer being the planning director.
Yeah, and the reality is on this one, it I think went through Stacy 3-4 reviews.
Yes,
Three.
sir.
And I think on neither one of them did Lugum staff turn up where they thought the setback applied or that a variance would be required.
Without a variance being required?
No variance would be required on this one.
It's because of the setbacks.
My understanding, I wasn't here last meeting, obviously, but my understanding is that the record includes a certified letter from Roan, from the tower manufacturer, that this tower is designed, it's designed, if it fails, to fold on itself.
I follow that. We've been through that. I don't know how many times with Mr. Fisher. I understand all of that. They're supposed to fall right in that cage.
Right,
Okay?
right.
I got to be careful here. Crap happens, okay? Okay? And if someone has a property line that's adjacent to this piece of property and adjacent to your site that you want this tower to go on, someone from that piece of property has to be notified, and I think this board would like for someone, an owner, to give us a reason to give a variance.
Well, they were notified, correct?
It does, they were notified for the conditional use, okay? That's what we're here for, conditional use.
They were also notified for a community meeting, though.
They were notified for a conditional use, Mr. Fisher, okay? What
But
we
can
have
can I
in
just
front of
interject?
us.
We also had a community meeting, and we sent out letters to all of the adjacent property owners for a community meeting too, and shared all that information with staff. We did that in advance, of course, of the first hearing, so that way it gave everybody an opportunity to communicate. And we did have, I think, 2 property owners communicate and ask questions. We shared the photo sims with them.
Okay, is either one of those property owners that shared that information, that communicated with you, the property owner that's within that fall distance?
One of them is adjacent, but it's not within that zone, no.
Okay, is the property owner that you communicated with, the property owner that's within that fall line, in their property line?
It's possible, but I'm not certain, because I didn't look them up, yeah.
All right.
Because if you look at where the cell tower is going to go, it's to the right of there, where the distance is not the 200 feet. And that's why I wanted to know where each person was that has written in, that said, whether they were for it or against it. But I wanted to have an understanding where the locations were.
So the sheet C2 of the site plan lists the adjacent property owners. If you have the names of the 2 folks who wrote in, we can figure out whether they're adjacent and where they're located.
Hold on. One was.
Menna, M-E-N-N-A,
Okay.
Gagnon,
What was that? G-A-G-N-O-N?
G-A-G-N-O-N, was another one.
One of them
Those,
sh-
those,
Those were the 2 that were against.
those were the 2 that we received written comments that they were against this, okay?
One of the positives is an email name, but that provides no real name or address in the correspondence. That's one of my questions of staff.
And then there's a Mr. Lord that was in favor of it, but I'm not sure where he's at.
We have Mr. Mena, with adjacent property owner 4, which is right next door.
Can you
Can you show us,
show us on,
Ms. Clements, please?
Okay, yes, Mr. Mena
Okay.
He was on the call.
is,
For the-
on the site plan, is property owner number 4, the tower, proposed tower,
for the
I'm
community
sorry,
meeting.
is right here, and this is his property.
We don't see it. There we go.
Okay.
Now we can see it. Can you do that again, please?
Yes. Say,
yeah,
I'm sorry, I'm not used to doing a PDF. Okay, so we've got Mr. and Mrs. Mena, are property adjoiner 4, and on the site plan, the cell tower is here where my cursor is,
Yep.
and the Menas are
Yep.
located here. There's their
And
home.
their property line is where?
This is the property line.
so how
there's
many
it.
feet is that?
Okay, from the cell tower to the proposed corner of the house is
No.
3.
No, to the
To
property
the
line.
property line.
Okay. Give me just a moment. I'll
It's,
break out my.
it's right there,
Yep. Give
but I
me-
can't read it.
58.2, sir.
Oh, gotcha. Yep, it is right there, 58.2.
Where are you seeing that?
And then from the actual cell tower itself is
From the pole
96.2,
itself, it's 96.
What is it?
right here.
What-
58.2 to the corner. To
Okay.
the property line. And then 96.2 to the cell tower itself.
Okay. And how about the other property line?
Yeah, but I don't know
No,
if
to
that's
the other piece of property.
against it.
Right, for the one to the east?
Yes.
Yeah, I'm not seeing any distances pulled for that
Okay.
particular property.
That line, is that the property line there? Where your
This is
cursor's
the
at?
Property line right here.
Okay.
So that's even closer.
Yep.
Yep.
Is that Gagnon?
This is, let's see, property owner 6.
I think that's Dodge,
Yes, Dodge. Miss
It's a
Nancy
big,
Dodge.
Nancy Dodge, trustee.
Okay.
huge, huge parcel.
That person didn't comment.
900-acre parcel.
Can you show me where the other person is?
Okay.
Like,
Do you have a name by chance?
Did we get any comments from Ms. Dodge?
I can double check the public comment. We got comment from Mr. Lord on the Gagnons.
yeah, that's who I want to know where their property
Okay.
is.
Let's see. Might be easier to
They're not adjacent.
go into
GIS.
GIS. So give me just a moment.
Okay.
Mr. Chairman,
Yes.
if I can, going back to the procedural issue, and you alluded to this, and that is, we have a conditional use, we have a variance. So under our rules, Rule 2-104, the institution and the notice requirements of both those types of cases, whether it's a variance or a conditional use, are treated in the same way. But the question I guess we have to ask ourselves, because when we look at the notice requirements, the rule says notice of a hearing of an application for a variance or conditional use shall be given by mailing, so on and so forth, but shall state the reasons and the rationale for the variance or the conditional use. And so I think the rule kind of implies that, it's either one case or the other. But what it does tell us is that notice has to be specifically given whether you're going to do a conditional use or a variance. And I guess I'd be concerned about whether or not there's been adequate notice and there's enough record in the board docs and the public records that we also intend to grant a variance.
That was my biggest concern, is that once it was brought up, I think, and
I don't know if John wants to comment on that. I throw it out there. I think it really is a matter of degree and how substantive the variance really is. I mean, obviously, this board, during a public hearing, can certainly pivot and respond to things that come up that may not have been specifically noticed. But I guess, like any other case, each case is different. And I think it really depends on how substantive we view the purported variance to be, and whether or not this board believes that there should have been notice to adjoining property owners and or the public that this is a conditional use and a variance.
right.
I can share some thoughts more on that. Again, if staff looked through this, staff did not note or determine the need for a variance. That is what it is. That is my official position. But I don't think a variance is required, and I'll stand by staff's determination on that one. If a variance is required, the best argument I can get is that when it comes to notice, the case law on it is that you have to give enough detail that a person of general understanding will know what the request is about or what the nature of the action is. In this case, we know that it's, whether we call it conditional use or a variance, we know that it's for approval of a 190-foot tall cell phone tower. We know the location of that tower. Whether we do another 6 weeks of notice for a variance and do another hearing, the plan and the facts are going to be the exact same as they are right now. The same people will get the same notice. Same people have notice that they have gotten. We know that the Gagnons got the notice who'd be affected by that variance. Ms. Dodge, I can swear me in real quick, because I'd have to provide testimonial knowledge on this one. It's not legal argument. It's not speaking from the ordinance. This is strictly personal knowledge.
You can give the oath, Mr. Chair.
Do you declare and affirm under the penalty of perjury that the testimony, responses, and statements you may give will be the whole truth and nothing but the truth?
Yes, I do.
Thank you.
Nancy Dodge, the widow of Dr. Norton Dodge, lives on Cremona, 900-acre farm, a very little bit of which is what's hitting. Mrs. Dodge, I knew her briefly when she was on the Historical Society board, and I overlapped with her. I doubt Mrs. Dodge is interested in participating in this proceeding. I get we can't take that much, but that house is probably about a mile northeast of her where she actually lives, and this property is a sliver of what she's got going on with her right there. Those are the two property owners affected by this one, and I get they've gotten notice. They knew where to come and get notice. They were able to see the site plan in front of it. The other concern we have got, and I would have to yield to counsel for the applicant's expertise on this one, is we are dealing with a cell phone tower, and there is a requirement that we process these in a reasonable time upon receipt of a complete application. I don't know exactly when we determine a quote-unquote complete application is, but I think we received this in early March, and there is an FEC ruling from about 2-3 years ago that says a reasonable time is presumptively 150 days, which you are already button up against, if not already over. My understanding is that if we go over, they call it the shot clock rule, and we fail to act upon that time, the application is deemed approved without any further action by local government. So if we do delay, we could lose the shot to do anything about this project at all.
I'm not sitting here to delay anything, okay? But part of our job here is to make sure that everyone is notified and has the opportunity to testify, whether it's written or verbal or not, either, but has the opportunity, and that everyone has to understand, and I really don't want to set a precedence of having a hearing for one item and adding a second item in and having something come back on us. Okay? I guess it's a fine line right here, right now.
No, I'm
okay?
sensitive.
The
and I think
fine line is 96 feet, okay? Is what we're looking at.
One learning lesson to take forward is that if the board feels that sentence means a certain thing and that is not how staff interpreted it in this particular application, obviously that is something to be corrected going forward. And again, I think just tactically, the issue in front of the board right now is
Okay, I'm
So,
gonna get to
you lose the opportunity to do anything with the site plan at
Mr.
all.
that. I
Hauser.
understand.
In your capacity as a factual witness, you can testify that the weight of the zoning officer is behind the interpretation that you've given us to the ordinance this evening?
Correct.
Okay. And I think ultimately, per the CZO, the zoning officer is the interpreter of the provisions of the zoning ordinance, and we all know there are a lot of them that require interpretation. There's always the between the lines issues that come up. I'm going to be a bit circular now, although even though the zoning officer is the ultimate interpreter, zoning officer interpretations are appealed to this board, so we're back
Right,
to
right.
us.
We've had that several times.
Yeah.
For us. So, Mr. Scott.
I guess I'm not helping, am I?
You know, if Mr. Hauser is testifying that the director is in line with what's going on, should we have Ms. Clements testify to that since he's interpreting her thoughts? Should we
I think
have
that
Ms.
would- I
Clements
think that would be
testify to that? That way it's on record that it's coming from the land use and growth management. And
Yes.
Mr. Hauser, I'm not doubting your interpretation
Understand.
whatsoever, but I just want to make sure that whatever we do here tonight is set and we don't have to worry about it.
Well, and I think from a procedural point of view, and Mr. Hauser is correct, anybody that would have seen board docs or noticed or gotten notice would know the substance of this case. There's no question about that. One of my concerns, though, is we know the elements of a variance are different,
Right.
and they require unique circumstances that create an undue hardship. But I'd be much more comfortable from a procedural point of view if we rely on, if we're going forward, the zoning officer's interpretation as opposed to pivoting to require a variance.
Okay.
If I may, then, I might, switching back to the hat as leaving the fact witness, my debut is that aside, and counsel, if I could maybe walk Ms. Clements through that questioning and try and lay that factual predicate.
Okay.
Got it. Ms. Clements,
So-
could you,
Yes.
just for
Did Ms.
repeat's
Clements
sake,
get the oath tonight? Did we swear you in? I don't remember doing that.
Yeah,
It's a good.
Do you declare and affirm under the penalty of perjury that the testimonies and statements and responses you may give will be the whole truth and nothing but the truth?
I do.
Thank you.
Ms. Clements, could you start, and I know you said earlier, but just to get me off to a start and let me find my stride here, give us your title at
My
the Department of Land Use and Growth Management.
I'm a planner for. I work with development services supervisor.
And as a planner for, could you just elaborate on what your duties are? What's your day-to-day work? What sort of tasks you perform for county government?
I oversee the planner 2 and the planner 3 that completes the site plan and subdivision reviews.
If I could summarize that, then, is it accurate to say that you, in a supervisory role, have oversight of the development review process and the site plan review process?
Yes, sir.
Does that include determining when site plans are reviewed, whether variances or other departures or deviances from the county code are caught?
Yes, sir.
And did staff review this site plan for any such variances?
Yes.
And did staff at any of the reviews they conducted on this hearing note the need for a variance?
No, sir.
And how many reviews approximately over
3.
or did they complete? And over what span of time are we talking that those 3 reviews are done?
I'm not sure about
Least a
that.
year.
It was a good while.
Okay.
Yeah.
Ms. Clements, you've heard back and forth in the colloquy tonight. You heard what we said about staff determining a variance not being required. Do you stand by that tonight? And is that the determination of staff at this moment in time?
At this moment, yes.
All right. No further questions for Ms. Clements then.
Okay. Mr. Scott, do you have any?
I do not. No questions from Ms. Clements, no. Counsel for the applicant, I don't know if
Say,
you may have some.
Mr. Showalter, do you have any questions for our staff, Ms. Clements?
My understanding, the planning commission's also reviewed this project, is that correct?
No, sir.
Not yet.
It does not go
Not
through
go to
planning.
Okay, thank you. No
Yep.
further questions.
Thank you.
Okay. The only other concern that I have is with Mr. Mena, and that's the property line that we're speaking of. He had a, if you read his letter,
Okay.
third paragraph on his letter,
No. Okay. I'm trying to pull it up for you.
okay.
Okay. Nope. Yes.
That the Mena or Gagnon?
Mena. Or is that, she has, which one do you have up?
Okay. The subject, Gagnon.
Yeah, that's the correct one too. There's the question of safety.
Yes.
Okay, yes. Okay, Mena. And then this is also Gagnon. Okay. Is this the one?
It's it's going to be the last one. Keep
I'm
going
sorry.
down.
Keep going.
It's on the third paragraph, Ms. Clements,
Going down. Keep going down.
where it says there's also a question of safety.
Also, the question of safety.
Keep going down.
There's the.
Keep going down.
There we go.
Is it that one?
No.
Nope.
Nope.
Okay. Let's see. Alternative public.
Okay, I just pulled it up off of board docs.
Yep. I've got board docs up.
Okay,
so-
it should be the one that says comments from Mena.
Okay. The Tony Mena.
Yep.
Okay.
In the third paragraph, if you could make that a little larger, please.
Yeah, you got it in front of you, too.
Okay. And it says right there, these, the towers are tall metal structures and can be attracted light and stuff like that. Okay, that's just part of safety. But he has a question here. If I build a detached garage near the property line, which I plan on building, okay, this is what we had before on another case. It could be in the direct fall zone of the tower where even ever damage can come down, which is not, I don't know what that means. If the tower ever damaged, it could come down, okay? So my concern is, Mr. Hauser here, is the case is in front of us tonight. The guy says, I might, okay? What kind of weight should the board consider there? I'm trying to cover everything so we don't have to come back, okay, is what I'm trying to do. I'm just, these guys, these people have sent in comments. They're very concerned. That's why they sent the comments in. So we have to answer those comments. And I guess this should be under public comments, but we're in the fall zone kind of thing, so that's why I brought it up now.
And you asked what weight to assign it.
I guess so. I mean, you know, we've had cases before where the towers have been turned down because of structures to be built. But if you drive past that site, the structure still hasn't been built. So this is in line in front of us. If there's no permits there and it's just a thought process, I may build there later, I mean, there's a concern that the citizen had, okay? The adjacent property owner has. And Mr. Scott, you might be able to help Mr. Howes right here, the two of you together, to give the board some idea of what kind of weight we should use for that. And
I'm sorry, Mr. Chair. Our rules of procedure, section 5-104, talk about evidence. Generally, the gist of our rules of procedure is that it's really up to this board to provide whatever weight to testimony and documentary evidence that may be presented in any particular case. So I guess I have to lob that back to you all, including Ms. Clements' testimony.
Okay.
It's up to you to deliberate and give such weight to the evidence as you deem appropriate.
Okay.
Now, I do have a comment on that. I know the last time it was the person's house that was going to be built. A lot of times for a house, you have to, where perks and things like that, you have to have a specific location. I guess I believe for a shed, it could pretty much go anywhere.
Thank you. That's what I'm after. That's the kind of weight I'm after here, is I just want to make sure that we address the concern and give an answer to it. Okay?
The other thing I'll note, just for the record, is that as an applicant, we're entitled to the right of cross-examination. So
You
without
are.
Mr. Mena being present and being subject to cross-examination or answering any questions.
Okay.
it-
And when we
it
get
deprives
to,
the
when we
ability
get to the public comments, this was a board concern.
Understood.
Okay. When I get to the public comments, and if Mr. Mena's here, then he can testify and you can cross-examine him.
Thank you.
Okay?
One last contribution, Mr. Chair, because I too stumbled on the issue weight, but where I thought you might have been going with it was what right under the conditional use standards would you have to take action on those concerns if you felt them? And the standards are, and Mr. Scott's point about the standards that have to be met for a variance is very well taken, but you see that too in the conditional use standards, and you have some actionable things there for the concerns that would be raised by that potential variance. Namely, standard 3 at the conditional use will not be injurious to the use and enjoyment of other property in the immediate vicinity for the purposes already permitted, and that it won't have adverse effects and be of and beyond those inherently associated with a similar cell tower. And I think those could give the board some modes of righteous inquiry tonight, even in the absence of a required variance, if that's the route we go.
Okay. Thank you. Don't go too far.
Can I ask a question, kind of like traveling down another area? Okay, so where this access to the cell tower will be, coming off a Newmarket Turner Road, if I have the correct access, it looks like it goes through 2 other properties.
Ms. Clements, she can bring that up, right, Ms. Clements?
Yes, sir.
Okay.
So we've got Newmarket Turner Road right here.
There we go.
Can
All
you
right.
follow okay? It would go through property number 1, property number 2, the access, and then onto the subject parcel, go past the house and sheds, and then to the back of the property where the proposed tower's at.
So my question is, I know that the person that lives there has the right of way. Since this will be now leased to I guess you would say like a third party, do those people automatically have the access to the right of way?
So when these parcels were created, when the parcels were created, the subdivision plat established a right-of-way. So there's a platted right-of-way across both properties. There's a platted right-of-way across the road frontage parcel to get to the 2 parcels behind it, and then that right-of-way extends across what I'll call the middle parcel to get back to Mr. Adams' parcel. And a right-of-way that is available for use by a property is available for use by its owners, its tenants, its invitees, their guests. Anyone who's accessing the property with permission has the right to use that.
Okay, that's what I was,
So, Ms. Weaver, if I can add, I'd caution this board against making any determinations on the legal right of use of a right-of-way or easement. That involves often a great deal of careful study of the land records and our land records documentation, granting documents, and so on and so forth. I know there was a issue raised in this case about the legal right to use a right-of-way, but that's outside of our jurisdiction. We certainly don't have the right to determine legal rights to an easement or right-of-way or private roadway.
okay.
Any other questions at this time? Mr. Fisher, you all can continue. You may proceed.
That was a 5-minute deviation.
There's nothing else. There's nothing else.
Well, so I don't know that we have much else in the way of affirmative presentation. We'd like to reserve the right to respond to any public comment, if we may.
Okay. Everybody good? We open it to public testimony. Anyone wishing?
I have another,
What?
I have another question. If
Go
you
ahead.
don't mind. Okay, so on this packet that you gave to us, there's 2 different cell towers there. Could you please explain which one will it be?
Must be the RF.
Because one says proposed, and then it says,
Is this in the RF report?
excuse me?
RF report? Is this the RF report that you're referring to?
Yeah, it's on page 2.
Okay.
What's the title page say, Ms. Weaver?
What?
The front page, what is it?
Oh, I'm sorry. This one says June 2025.
Yep. So we have Narendra Mangra on the phone, I believe. Narendra, page 2
Right.
of the RF report. Ms. Weaver has a question.
Yeah, a question. I think we swore him in last time.
Almost swear him in again.
Okay, sir.
What's his name again?
Narendra Mangra.
Bankrupt?
First name Narendra,
Okay.
Narendra. Last name Mangra, Mangra.
All of that. Okay, let me get you sworn in before you start to. Do you declare and affirm under the penalty of perjury that the testimony, responses, and statements you may give will be the whole truth and nothing but the truth?
Yes, sir.
Okay, and then for the record, if you would give us your name and address again, please.
Sure. First name Narendra, last name Mangra. Address 4234 40th Street Northwest, Washington, D.C. 20016.
Okay.
And I'm at GlobeNet LLC. And I believe you're referring to the document, the alternatives analysis, page 2. And that shows 2 proposed TCG sites. The 2024 in gray was the previous site that was submitted, and the current proposed site is the one we are talking about, and that is shown in black. So the grayed
Okay.
out version is really from an earlier proposed site that was submitted earlier in 2024.
Okay, thank you very much.
Is she able to record that? Is Ms. Carter able to hear what he was saying? Do you know?
I believe so.
Okay. Yes. Okay, thank you, thank you. Did that answer your question, Ms. Weaver?
It does.
Okay. Anyone else have any questions before we go to public testimony? So we'll now open up to public hearing, public testimony. Anyone wishing to speak this evening? We have Amanda Wood. You can come forward if you'd like, please, if you would. And you can speak right into that microphone. Let me get you sworn in. Do you declare and affirm under the penalty of perjury that the testimony, responses, and statements you may give will be the whole truth and nothing but the truth?
I do.
Thank you. And for the record, if you give us your name and address.
Amanda Wood, 39420 Pinewood Lane, Mechanicsville, Maryland, 20659.
Okay.
So I'm going to read notes. I'm not as eloquent as I'd like to be on the fly. So we own the property directly off of Newmarket Turner Road in front of the proposed location for the facility. That anyone requiring access to that facility would have to cross over our property. We believe that the way in which this has come about was in bad faith. We were led to believe 4 months ago in this communication that they were reaching out on behalf of Mr. Adams in his continued use of his driveway, his residential driveway. It wasn't until we received the public notice letter in the mail a week prior, like 13-ish, 14 days prior to the first hearing last month, did we learn of the true intentions of the easement that we were being negotiated with. As soon as we received that letter, we rescinded our approval or agreement of any negotiations that we had with opposing counsel. So despite the false pretenses as a small-scale developer seeking to improve improve properties, especially in our area. We live in Mechanicsville as well, with some affordable new builds. Things these days are just so huge and so unaffordable. The cell phone tower would decrease our property value and along our property and those on Ruston Way and anyone impacted within a certain radius. And it certainly would impact our small business directly. I'm not sure when the community engagement meeting took place. We were not given notice. Granted, we've only owned the property since February of this year, so it might have taken place prior to our taking over. So we weren't notified. We didn't get that opportunity to give those comments, hence why we're here today. And it's my understanding that one of the letters that was made public for this hearing is of a renter that's in favor of the tower, is a renter. He's our neighboring property, and that he is not an owner. So he has intentions of procuring the property from the owner, but in the future, but who knows if that's going to happen. He's not an owner, he is a renter. And speaking on a personal note, and also kind of counteracting what was said, that although Nancy Dodge may not care about the property that neighbors the cell phone tower, as it was mentioned, she has a beautiful house on Cremona, in which we spend quite a bit of time on that farm. She might not have thought it pertinent to respond to the letter, but with that said, she also doesn't live next to the cell phone tower because she lives on this beautiful farm. So perhaps this wasn't of importance to her because she doesn't have to live next to it. So I believe that's where we are today. We do maintain the position that although title is not a part of this appeal, but as a public, and it is still our understanding and our position that they do not have easement access through the 50-foot right-of-way, utility access. So that is something that we are trying to negotiate offline, and not for this forum, of course, but that is a position that we maintain. And that was in bad faith. All those few months ago, we were contacted shortly after procuring the property of someone who was just acting on behalf of Mr. Adams and just trying to help him out, trying to get his access because he's been using it for so long, just wanted to make sure it was all squared away. He's an older gentleman, doesn't do email. We're just trying to help him out. Like I said, it wasn't until last month did we learn of this public hearing. And it was certainly not through opposing counsel who was conducting negotiations for an easement of utility and access with us. So it was not in good faith.
Okay.
That's it.
Is that all?
Yes, sir.
Okay, just hold tight. Anybody have any questions for Ms. Wood?
I do.
Go ahead.
Is the road, is that dirt? Is it paved?
It's dirt. Right now, the 50-foot right-of-way is wooded. It is not cleared at all. The driveway in which the property directly behind us has deeded access, Mr. Adams does not, but this was all family property, and that is all the title information that we have gone through that stated it was never a deeded access to him, but that is a dirt drive. And I'm not even sure it's quite wide enough for, I mean, my husband and I own a construction company. I don't know how they're going to get Smeco utility trucks through there. Like, they would definitely have to do construction to that road if it was utilized. In my understanding and my personal opinion, that road isn't sufficient.
And who maintains the drive?
When we procured the property, there was not a road maintenance agreement amongst the owners. So I don't believe that anyone truly maintains it officially. I think it's just kind of a good faith thing.
So how does Mr. Adams get back? If your right of way,
Dirt driveway.
if your right of way is wooded,
Mm-hmm.
and that's is where they plan to go through?
There's two accesses. The driveway was put in long ago, and Mrs. Adams owned the property, and it was all one parcel. And they just, as a big family, put in this dirt drive, and that's just what they've all used. But there is also a platted 50-foot right-of-way that is not cleared, is completely wooded. That is that that landlocked use, but because they've been using this dirt driveway for decades, that's just what they use. However, he doesn't have deeded access. Only the property directly behind us does. So I can't move that driveway one way or the other. But there is a 50-foot access, but it's unusable at the moment.
Okay, all right. I don't know that, like Mr. Scott said, he can address that right-of-way thing. I think he did earlier, but if you can,
Yeah, I think, again, legal rights to a right-of-way, a property right, which is what it is, are more properly to be decided by a circuit court as opposed to this Board of Appeals. Our jurisdiction is limited to what is set forth in the zoning ordinance and in state law, and we certainly don't have the right to hear or determine that kind of dispute.
right, okay. So the option for Ms. Wood, if they were going to go through that 50-foot right-of-way of hers, she says is hers.
Yeah, and I think Chris Longmore does represent.
So
Yes.
their option would be circuit court for that.
Yeah, and I believe I heard the witness say they were discussing it or negotiating it as well.
We're in conversation,
Yeah,
yes.
so that's always good discussions. But yeah, ultimately, I think it would be a court that decides that issue if it can't be resolved.
Okay. Does that help you out any? I mean,
Not necessarily. We're of opposing opinions on this matter. So although that we're in negotiations, TBD.
right, okay.
I have one simple question. You are beyond the 200-foot radius from the tower, correct?
I believe so. Yes, sir. We're in the front. Even where our proposed, and you might be able to pull up the site plan.
But your
and tell-
property line is beyond that 200 feet, right?
I'm not sure. I would suspect just by looking at that GIS right there, but
I mean,
my depth perception is a little off.
the tower, here's where her house will go.
We don't, do we have a dimension?
So we don't know, or can you measure it?
Yes, it's up there. It's over 600 feet.
Here right now.
There you go.
600 feet?
It's over 600 feet, she said.
Okay, that's all I want to know.
Okay. Questions? You have any questions for Ms. Wood?
No.
Okay. Thank you.
Thank you.
All right. So when was your community meeting?
It was a month before the first public hearing that we had here. It was a month before the first public hearing.
So-
Stacy, we provided Stacy all the documents for that.
Okay.
So it was March. When was the first public hearing? It was June, right?
Yes.
So April.
And we sent notice to everybody.
Okay. So the same folks that you sent the notices to got a notice for the public community meeting? Okay. All right. In the same way? Okay.
And also with the young lady who just spoke, the existence or the possibility of a cell tower has certainly not been a secret for a long time. So, because we've been talking about the right-of-way issue.
No, just listen to what she's saying. It's probably the way it was delivered. Okay. Communications means a whole lot. Delivery means even more. So as long as everybody was on the same page, which doesn't sound like the Woods were on the same page as far as with the communications, is what I get out of it. So, okay. And we have 4 written communications, right?
Yes.
Okay. And I think we'll address that. We can't, that's property values. We have no set comments from any real estate folks that we don't have any information on property values as it pertains to communications towers. Is that right, Mr. Scott? I think
That's
we've had this
correct,
before.
yes. I don't know if the applicant wants to comment on that. That's a fairly common
Yeah.
concern in a land use application. So I don't know if the applicant has addressed that before in other hearings or would like to address that tonight.
I'm happy to do so in two respects.
Well, before we do that, if we don't have any more testimony, let's close the public testimony, written and verbal comments, okay? And then we can get back into these questions. Go ahead.
Okay. Well, if that's the conclusion, and this is essentially closing argument, let me just address it.
Well, no, let's one would just answer the question first, and then you can get into.
I'll do it, and I'll come back.
You'll have a
Absolutely.
question of staff.
We still have other questions and stuff.
Okay,
so-
all right, I'm sorry.
I have a question of staff.
Well,
as
let's,
relates to one
let's,
of
he
these split
needs to
letters.
answer this question first, okay? That we had here.
Yeah, so the answer is when you look at the legal standard in Maryland for a special exception, once an applicant demonstrates that the project complies with the code and the county staff and the county staff report indicates that it does, the burden or presumption, if you will, is in favor of approval of a special exception. And the board has to grant the special exception and follow that presumption unless there is evidence in the record that overcomes the presumption. So there's case law in the state of Maryland that makes it very clear that, layperson suggestions that a cell tower or a crematorium or some use that's a special exception use might cause an adverse effect on property values. The courts have said that amounts to no evidence at all. You have to have evidence of actual effect. And it's not a question of whether a cell tower would cause an effect. It's whether this cell tower at this location would cause an adverse effect that's greater than a cell tower in any location in the county. So I would submit there's no evidence in the record that there's an adverse effect caused by this tower. And in fact, the tower is going to provide additional connectivity. So in many cases, in today's digital age, people want to be able to connect in their homes. And the reason why there are needs for more towers with 5G service is carriers have to provide more robust service to provide the access that people want, both on the road and within their home. So we think this value actually is neutral at worst and probably enhances value of properties because it will have greater connectivity when it's constructed.
In that 1 mile radius.
Slightly more, 1.6?
No, one antenna on every mailbox.
Right.
Remember that.
Right. No
I have a
negative effect.
question.
Go ahead.
And in terms of a record, there was an email from an LOLVIDER, but there was no name attached to it. Do you know who that person is and have their address?
No, sir, we do
So
not.
really, it's a unknown input that was a positive input. Okay, just question.
Photos. I'm just going through my notes here from the written comments that if we haven't covered something. The only other thing I see here is that Cremona is not a historical site.
I'm sorry, say that.
Cremona itself is not a historical site.
Is it a?
Is it a historical site? Mr. Hauser
I can.
is our history buff here.
Remember, I'm sworn in. Cremona, I think a build date of about 1815, 1820. It's one of the premier brick Georgian federal-type manor houses in St. Mary's County and one of the few extant remaining. Dodges have had it for several decades. They, again, I think Norton passed away some years ago. My understanding is it is under a historical easement, and I believe his going to the University of Maryland University system once Mrs. Norton has no further use of it. As far as the grounds itself, too, I think they are also under an additional conservation easement. And Stacy, you, I think, can bring that up on the GIS if you go down to, and we can see, I don't know if it's Mount Rural Legacy or another, but click through those and see if they hit, because I think
it's DNR.
We have other easements,
through it.
protected lands,
Try Rural Legacy, see if that comes up.
rural legacy.
Okay. I think my father, John Charles Hauser, a forester, had some experience with the family too beyond. I think I recall him telling me that it was protected, preserved land as well. And it is rural legacy. Stacy?
I'm sorry, the site itself? No, it's got. The site itself is impacted by.
Not the site, the Mrs. Dodge's property.
Oh,
whether
next
that's
door?
under an
Okay.
easement. Yeah.
Let's double check. Yes, it is rural legacy, definitely.
I That's what I know about Cremona off the top of my head.
Okay. Is it any, the only other thing that's a concern here, is there any impact on the historical site from this tower?
No, the historical site's about 1.5 miles away. Cremona's on the water on the
Right.
Patuxent. Yeah.
I mean, they flew, in their presentation, they flew, I don't know, a balloon, but they had a place up there where they took several pictures from different locations, but they didn't take anything from Cremona side.
Yeah, that I'm not. I do know Cremona's a distance away, but I can't speak more than that.
More importantly, we have a NEPA. The NEPA would have caught all that.
Right? Am I right in what I'm saying? So it was all down Route 6, Newmarket Turner Road on both sides, and a couple of different angles from off of Route 5, but nothing from the Cremona side or the River Shore side.
That's right.
This side, right?
Mm-hmm.
Where is it? It's down here.
John can better.
The house is up here, right? Area of interest.
That makes sense.
I mean, so this was still taken from that side. Yep.
So we good?
Answer on.
The question again, sorry.
Pardon?
What was the question again?
Is there any problem with the tower and the historical Cremona location as far as, and I think the CZO's is a visual impact on the historical site. If so, then we have to look at it differently.
The answer is no. You have a NEPA in your packet that's required by the federal government, by the FCC, and that NEPA specifically looks at historical properties. It's one of the reasons we chose this site, because it's distance from there. So the NEPA is, it's very thick. It's part of your packet. If you care to read it, obviously it's a lot of reading. But it's not only a federal requirement, but it's also a state requirement for SHPO. And so the state looks at it, the federal government looks at it, and they make the determination. And the determination was, after the study, there was no impact
Okay.
otherwise on the historic property.
All right. We'll take that.
You have the visual simulations in your record?
We do, but we don't have anything from the Cremona side.
Well, so you don't, but I'll just point out, there are two views, so that house of interest is located northeast of the site, but there is a view that's about 800 feet east of the site.
Yeah, but that's over on Newmarket Turner Road.
It is, but it's in between
I
the
understand,
house of interest.
but it's up further from that than the way that angle would go to
No,
Cremona.
I understand, but I mean, if you look at that one, which is only 800 feet away, you can't see the tower in that image.
I understand, but different location gives you different visuals.
Understood.
Okay? We good?
Understood.
Thank you.
The NEPA has pictures too.
Anybody else have anything?
No.
Oh, yeah, I had one question.
Yes, sir.
It says, the only visits to the site will be for emergency repairs or regularly scheduled maintenance visits 1 or 2 times a month. What are we talking about here?
How often is the site visited
No, what are we talking about?
in terms of what they're doing?
Yeah,
So typically when they're visiting the site, they're just checking on the technology that's inside the fenced compound and testing it and making sure that all the testing equipment is working properly, so the signal's working properly. That's the most common reason.
well, let me ask you this.
Sure.
Okay, so you're loaded up with carriers. So Verizon goes out and checks all these other vendors that they're selling the site to? Is that correct?
So the pole is built to ultimately hold 4 to 5 carriers because that's the requirement in the
Right.
county ordinance. And increasingly what we're seeing is that companies such as Mastech, gentleman behind me, and other companies, the carriers outsource to them, and increasingly they're outsourcing to the same companies because they're all being consolidated, so the visits were actually decreasing, not increasing, because obviously it's so expensive to send personnel out to the cell sites. So so your question, if I if I'm listening properly, is if you have 4 companies, would that be 8 visits per month? And the answer is it could be, but increasingly we're seeing the carriers using the same vendors. And those vendors are doubling up when they visit.
Yeah, they're just changing hats then, yeah. That makes more sense. And when you say scheduled maintenance, would they start the generators up or whatever, or mow the lawn or
They could,
trees? Or,
so I think this particular site doesn't have landscaping because it's surrounded by trees, so we didn't want to cut down any more trees than necessary. So scheduled maintenance could be the stormwater management facility that's required in the front. It could also mean the making a repair to the fence, if a tree hit the fence, let's say, which
right.
is unfortunately very common.
Okay. Thank you.
Yes.
I have one, and it's just a comment. I know in the last meeting, you kind of went on and on about batteries in lieu of the generators, and you kept saying the batteries were restored off the grid, and all I can think of is one major ice storm way down here. And when you're off the grid for a week, and your only connection has been through cell towers and stuff, you're possibly, my reaction is I would question seriously moving away from generators.
So that's a great point. So the carriers, here's the simple answer. The carriers are required by the FCC to have backup power for good reason. So that way, when the power does go off for your house, your phones will still work. It's extremely important. How they provide that backup power is completely up to them. And when I mentioned the battery, maybe I was giving out too much information. The battery storage actually lasts a lot longer, potentially, than the generator. I haven't seen a lot of this happen yet, but it's coming.
Well, I just remind people that sometimes we're off the grid for a very extensive period of time. You probably know it from your last tornado incident.
Yes, yes, indeed.
Any other questions? You want to present your closing statements?
I'll be brief.
Okay.
So again, as I noted, the standard for special exceptions in Maryland is established when the county determined that cell towers should be a special exception use. They recognize that that's a use that might have the potential to have adverse effects on other properties, and that's why it's before this board for a project-specific evaluation. But under the case law, it's very clear that when an applicant submits an application and that application meets the requirements of the county code, it's entitled to a presumption of validity. And the board's denial of a special exception requires there to be substantial evidence in the record relative to one or more of the standards that you have to find for approval of a special exception. And those relate to whether it's contrary to the goals, objectives, or policies of the comprehensive plan, injurious to the use and enjoyment of adjacent properties, and others. The staff report walks through each of those, and the county staff finds that the site will not be detrimental to surrounding properties, is consistent with the comprehensive plan, will not have adverse effects above and beyond those that are inherently associated with cell towers. So the staff report, I think, very appropriately addresses those, and I'd like to incorporate their recommended findings as part of our presentation. And I would submit to you that where the record does not include substantive evidence to overcome the presumption, the board should approve the special exception. We appreciate your patience and your consideration, and thank you for your time.
All right, thank you. Okay, folks. Comments, discussion?
Just kind of going back to one of the persons concerned, Mr. Mena, about his shed. I believe, not much weight should be given to that since he could put the shed anywhere on his acreage. unlike the situation we had last time.
The only question I had, sir, was we talked about this approval and a variance. So I just wanted to voice this scenario. Say we approve it and we do something with the variance, then Mr. Mena puts a garage and that tower does not collapse on itself and it falls and hits on his property, on his structure. Does that create any liability for the St. Mary's County where Mr. Mena can turn around and sue because we didn't do it the correct way or announce it? That's the only question I really have.
I think where I would be right now is, especially after we took the opportunity to swear Mr. Hauser in and hear what he had to say as part of what he believed the director was thinking when they looked at this project, and Ms. Clements's comments, is that if Mr. Mena wanted to get a permit, he could, knowing that fact now, is the way I see that. It's like Ms. Weaver said, he has the opportunity to put it wherever he likes. If he likes to put it within the fall range, he could, okay, knowing what could happen. So it would be up to him. Am I surmising that pretty close, Mr. Scott, of what we got from Mr. Hauser and Ms. Clements?
Yes, and I do think also the testimony about the technology of the tower and how it collapses upon itself, I think that's very, very important. I think Mr. DeRoca's question is a very complex one. I think you could ask several lawyers that, and they could give you their opinion.
Oh, no.
My opinion's no. I don't think so. I think we have a reasonable basis in the record for if this board sees fit for an approval.
Right.
I think the testimony by the staff, as the chairman points out, is important. I think it's based upon planning and zoning professionals' very thoughtful look at the CZO and their conclusions on the way in which the CZO should be interpreted.
Yeah, and he had an opportunity to be here tonight too, so we could, council could cross-examine. So, all right, thank you for letting me ask that question.
Okay, thank you. And Mr. Brown, you have any comments?
Oh, I hate to be the negative guy here. I kind of believe that, I believe in precedents. We've gone through 8.5 years of reading the rules one way, and we have one interpretation tonight. And as I say, if you sit back and back away, why was that ever written? If it wasn't written, then we would be proceeding just like we appear to be going now. But the fact that it was inserted into the zoning ordinance suggests the intent was to restrict anything within the fall radiuses. Also, the question as it relates to fall radiuses across the property lines. So I just have major reservations, plus the fact that we are, shall we say, it may turn out to be the same results, but the fact that the people in the area, when you see what do we want to call it, the conditional use versus a variance are two different worlds. And I'm just saying, we're doing a variance here, and I'm saying, whoops, I don't think we've adequately told the public, even though it may be the same people and the same results. As far as worrying about what the federal government would say, if council wanted to push that point, well, they would win anyway. So, I mean, it's a question of what is does precedent have weight here as opposed to a last minute interpretation? What was the intent of those two paragraphs as it was put into the zoning ordinance? That is what needs to be known. I'm sorry, I have some issues here that I have really concerns that I'd like to have cleared up. And also that Mr. Fisher has come before this board multiple times, and he is very much aware because we have constantly affirmed this issue of the full fall radius, and he has attempted to comply in every other case. So again, I think we're kind of rushing to judgment here. Enough said.
Thank you. Mr. Payne?
Well, it's a lot of things I don't understand here. It's, all this stuff comes in at the 11th hour. What have we been doing the last few months? It's really bothersome. And then Mr. Hayden made a good observation, I think, about the, was it conditional use or variance for conditional use? Seems like it's a lot of loopholes here, and it's a lot of perhaps litigation might be going on, about this daggone road. And it turns out, I was really ready to support this, but, with all this bomb that's blown up in front of my face, I'm not so sure. I'll have to give it some thought.
Can I add one more thing to my comments that I overlooked?
Yes.
When in the summary, you're suggesting that staff did a great job, but the standards for grading a conditional use that was in the staff report, in fact, and it's stated accordingly, was taken directly from Mr. Fisher and council's submission. It was a word-for-word transcribe of it.
Right.
It wasn't a suggestion that staff itself had put forth their own verbiage. Enough said. I just.
Thank you. Thank you. Thank you. The, and I'm still, I appreciate Mr. Hauser's comments and I appreciate Ms. Clements's comments, but I'm similar feelings like Mr. Brown has, is that are we setting a precedence? I think both of them are two different animals. And the conditional use and the variance. I think we have an issue down here at the bottom of that property there with, I'm not comfortable with it. I'm not comfortable with having it within 90 feet, less than 100 feet of someone else's property at all. And I don't know that we should set a precedent, to be honest with you. That would be my opinion. So, any other comments? Then who would like to make a motion?
Not me. I wouldn't know how to word it.
So, Mr. Hauser, I mean, not Mr. Hauser, Mr. Scott, I'm not getting a warm feeling from the board itself this evening in this.
Yeah,
because we're trying to work in a variance that wasn't advertised.
I see that, yeah. And I think,
I just have a big concern here, and I don't want to do something. I don't want to stop these folks from moving forward with the tower, okay? Because I think it's probably necessary, even though it's not going to help me out where I live. But I think it's necessary for the folks in the area. But I don't know that this board should really step out on that limb and trying to work in a variance here with a conditional use, and the variance wasn't advertised. I'm just.
yeah, I think that,
So reading the temperature of the room. It seems we do not agree with staff's determination of
Well,
variance.
I'm not going to say that, okay, because I think staff probably believes in what they're doing, what they're presenting, okay? But the way get is that the board, some of the board members are not comfortable applying a variance to a case that hasn't been advertised.
Okay.
Okay, and I believe that you believe wholeheartedly that the Director of Land Use and Growth Management made her determination on the facts that she had in front of her. And I also believe that Ms. Clements, I respect her a lot, and I respect everything that she gives us, okay? And I believe that she believes that they're heading down the right direction with this, okay? But where I feel the board is they don't want to set a precedence here, is the
So
way
the
I
issue-
get it.
If I could get it, then my sense is reading it, it's not the merits of the project, it's that the process was
The process,
imperfect.
yes, sir.
And I think our issue is that the effect of a denial of a conditional use, if we just did that without measuring it, CZO says it can't be brought again for 2 new years. And I think I can think of 2 ways forward on this one.
Because I really don't want to deny it.
I get it.
I really don't
I
want to
get
go there, but I think because of what was the facts that had been brought in front of the board this evening with the variance, it puts us in a precarious situation that if we did it tonight, who's to stop someone from coming and say, you did it for this, why don't you do it for this, I don't want to get
Yeah, and I think
Why could-
prior to passing on the substantive merits of the case, I'm reading the room as well, and I wonder if, again, as Mr. Hauser said, it's the procedural issue that is maybe more troublesome, at least at this point.
I think if I'm getting it correctly, if I'm getting the right feel here, is the procedure.
Yeah.
That what I'm getting?
The procedures.
Yes. That's,
So
that's
I
what
could,
I'm-
That's
I could think of
part-
two, I could think of 2 ways to cure I'll just go ahead and still call it a perceived procedural defect for the moment. One would be to approve the conditional use on condition it go through a variance, or if the applicant would so deign, withdraw the conditional use right now so that there's not a vote tonight that would result in denial, reapply for a conditional use and a variance, and we get it on post haste at
I
first
wonder
date we
if
can.
counsel for the applicant may want to comment on the procedural issue.
Yeah.
It seems like you might want to, Chair, if you give that
I'll indul-
indulgence.
Yes,
Yeah,
absolutely.
Yeah, so I think at least one other alternative is the standard that you're looking at and wrestling with doesn't say you can't be within the fall radius, but it talks about either getting written consent or an easement, or you're considering this variance question. So I think another alternative would be you could approve the use this evening on the condition that the applicant either obtain the consent or secure a variance. That would then put the burden on us to work with the neighbor or come back to you and obtain a variance in the future without combining them.
I'm
this
good with
evening.
that. I'm good.
That is-
I'm good with either one of those.
That is certainly within the board's purview under the CZO, yes.
And the record includes, information that the property to the east is already encumbered by a rural legacy.
Right.
I think we're only talking about one parcel.
One line. That's all we're talking about is one line. And like I said earlier, I don't want to deny it. I really don't, because, because if we do deny it, then they out. So if we can, I'm okay if the rest of the board is okay with approving the conditional use with a condition that the applicant either attains certification from the owner that they're okay with the fall zone thing, or go for seek a variance. Either way, I don't care. But I think that we need to move them forward from this point. We can't pivot on this line right now. Where I'm at.
Agreed, I think that's a good summary.
I don't see any issues with the conditions suggested by counsel for the applicant as far as staff go or our ability to administrate that.
Say that again.
I don't see any issues on staff side or our ability to administer the condition that counsel for Mr. Fisher proffered.
Okay.
Mr. Showalter.
Does that sound doable, guys?
It's good to me.
Okay, so,
Donnie?
Yes, I'm
Is
just
that-
writing down.
okay. I just want to make sure that we can move forward with this.
You think you can word it right?
Okay, I wrote it
We'll
down. Let's see.
We'll help you.
Okay.
ahead.
In the matter of CUAP 25-003, Drift-In Communications Tower, having made a finding that the standards for granting conditional use and the objectives of Section 51.3.91 of the St. Mary's County Comprehensive Zoning Ordinance have been met, I move to approve the request to allow the proposed communication tower, commercial use 91, within the Rural Preservation District with a condition for the applicant to gain certification from the owners for full zone or obtain a variance. Is that okay?
Can I, just to clarify, I think you said owners plural. So I think the only.
Owner.
Owner singular. And what the code refers to is a notarized statement of an agreement or an easement.
Yes,
So just, that's what the certification you're
right.
referring to is.
Notarized statement or easement for
Or
that.
easement.
Okay? Or seek a variance,
Secret variance.
Right.
okay?
That is correct.
I have a motion on the floor.
I'm sorry, can I clarify, seek a variance from section,
Correct.
yeah,
I would automatically think that they would put that in, but yes, from the,
subsection 10 of the
yeah,
applicable use.
And across the property line. But that-
okay,
Yeah,
you got that right?
yes.
Okay. We good?
Okay, I second the motion.
Okay, we have a motion and a second, and we'll start with Mr. LaRocco.
Aye.
Aye.
I'm still thinking.
Mr. Payne,
Aye.
Mr. Brown.
I'll say aye, but you better seek a variance.
Aye. Okay. So, you've listened to the board, you've got their responses tonight, okay? And their vote unanimously to support your application with the conditional use. okay?
Understood. Thank you for your time.
And an order reflecting the board's decision will be prepared by staff and signed by the board within 60 days. A 30-day period followed from the date the order is signed, during which any aggrieved party may appeal this board's decision in circuit court. And the recording secretary will email you a copy of the order once it's been signed. Okay?
Great.
All right. Thank you all.
Thank you.
Thank you.
Question is, if he seeks a variance and he gets it done within the next month, or would he be appearing before the board before the order is in fact signed and approved? Or are we forcing the counselor to prepare it immediately?
Preparing the order in time for the next meeting won't be trouble. Well, it'll be done on this one,
What
but
was
I
that?
can't hear you, John.
preparing the order in time for the next meeting, which is August.
14th,
That's putting you in the grinder.
August 14th.
I just want to say, I don't know which way Mr. Fisher's going to go. I'm just saying, if he seeks a variance, are we going to be having to act on something before we have an approved order? That's all I'm
No,
asking.
that I would rate the chances of that cosmic certainty it won't happen that way, just because of how long it would take, even if Mr. Fisher came in tomorrow.
He'll
with
give you a
variance.
forewarning, I'm sure.
Yeah.
A day or two.
So I think before he can even come back for us for a variance, he's got to wait 30 days from after the order which is signed, to which any aggrieved party may appeal this decision in circuit court.
I think we'd take that in.
I don't think that necessarily follows.
No, but I'm
think-
saying, once the order is signed, it's 30-day period from the date the order is signed in which anybody can appeal this circuit court.
Yeah, I understand,
So he
but-
wouldn't be back here before the variance before that end of that 30 days, right?
Well, and I think it's a moot point because I think Mr. Hauser's right, given staff's calendar and our calendar, it
Right.
probably is not possible. But I think the variance and the conditional use, I think the variance could be granted during the appeal period of the conditional use, and the variance becomes moot if the conditional use is appealed and
I was trying to answer his
overturned.
question. I guess.
Yeah,
It upset the cart a little.
yeah, you are. Yeah, I saw that.
Okay,
Make Mr. Fisher sit here a little bit longer.
I think we're good. Thank you all.
Thank you for your indulgence for my late arrival.
Okay. We won't hold that against you next time. All right, the July the 10th meeting minutes. Anyone have opportunity to take a look at those?
Yes.
Any comments, corrections, deletions?
Yeah, I think there's a couple corrections, sir. Didn't you have one, John?
No,
No.
I had a question on an order. That's
Oh, okay. I didn't see anything wrong, sir.
Anybody have any,
No.
just a motion to approve them, please?
Motion to approve the minutes as recorded.
Second.
All in favor?
Aye.
Thank you. Variance approvals, orders approvals, I should say, variance VAAP 24-0345, the cottage apartments. And that was a buffer yard variance. And we voted to, that was from the 65 to 30-foot type C buffer. And we voted 5-0 to approve that. Just need a motion to sign, unless there's a question or.
I have the one word I believe that Mr. Hauser's well aware of. I pointed out to him. On page 7, you're going down to the paragraph that says to the third standard, and it's the third word from the end of that paragraph is the word produce is in there, and I think he meant the word check didn't catch. I think it was product, because it was a good word, and he's aware of that he will correct that. But just be aware of it.
So did we get a motion on that? I don't remember, I
I'm
didn't.
so moved.
Okay. Is there a second?
Second.
All in favor?
Aye.
And the Vitalman property, VAAP 25-0400, exceeding lot coverage on that one. To replace the house and the porch in the critical area buffer, and we voted 5-0 to approve that as well. A motion?
So moved.
Second.
All in favor?
Aye.
Aye.
Thank you. And the Parsons Order VAAP 25-0306. And the critical area buffers disturbance to construct a deck. So we voted 5-0 to approve that one. Need a motion?
Motion to approve is written, sir.
Second? All in favor?
Aye.
Aye.
Thank you. Next meeting is August the 14th. We have 3 cases in front of us. That's it? Ms.
Yes.
Clemens, you have anything for the good of the order here?
One of them's a setback variance and 2 critical area variances.
Okay.
Yep.
Motion for adjournment?
Motion for adjournment.
Second.
All in favor?
Aye.
Thank you.
What did I tell?